Good afternoon, ladies and gentlemen. Many thanks for tuning in to the first of our second series of webinars from our Rural Disputes team here at Sheffield and Wedderburn. Your speaker today is myself, Alexandra Smith, solicitor within the Rural Property team in Aberdeen. Apologies that this isn't going out live, however, hopefully everybody who has signed up will receive this recording. My contact details are on this slide here. You will receive a copy of the slides, so please feel free to email any questions or comments that you have after you've heard the recording. We're going to look today at residential tenancies. We're often asked to give advice on different types of residential tenancies, so I'm just going to take you through the different types that are currently in existence, how they are regulated, and the provisions on termination, rent review and succession. Depending on when the lease was entered into, who the tenant is and the basis of the tenant's occupation will depend what type of lease has been created. On the 1st of December 2017, private residential tenancies were introduced by the Private Housing Tenancy Scotland Act 2016, with the resulting effect that most, but not all, residential leases entered into from 1st December last year will likely be a PRT, a private residential tenancy. However, residential leases entered into before this date may be one of a variety of different types of leases regulated by different rules. It's important to understand what type of lease is being created and how they can be terminated. Particularly in the rural sector, many estate owners and farmers will have a let cottage on a farm to a third party. Whether this is for a rental income or to an employee, it's important to understand the effects on both tenants and landlords depending on what type of lease is being created. It's especially important to have properly constituted agreements with employees to avoid the tenancy being anything other than a service occupancy agreement in line with the tenant's employment, and that we do not inadvertently create a more secure type of tenancy. That being said, this webinar will aim to look at the different types of leases in existence, and I hope to take you through that now. Before that though, let's consider what's required to create a lease. There are 4 elements: property, parties, rent and duration. If you have the first 3 of these, a lease will be deemed to have been created for a 1-year duration. The lease does not need to be in writing, but without a written agreement, the landlord has less control over recovery of possession and regulating rent. In terms of the property, whilst it's important the tenant has exclusive use of part of the property, they do not need to have exclusive possession of the whole of it for a lease to be created. For example, a farm worker sharing a property with another farm worker, it would be presumed that each of them would have exclusive possession of 1 bedroom and then shared use of the remainder, and presumably the lease will reflect that situation as well. Each worker therefore will be a tenant of that property in their own right. The exception being if the landlord lives in the property, a lease will not be created. It will be a common law tenancy and not one regulated by legislation. The property must be a private residential property and needs to be the tenant's only or principal home. Farms, holiday lets, student accommodation and offices will not therefore be a residential property and will not fall under the legislative remit of the legislation surrounding residential leases. In terms of the parties, the landlord must be a private individual, not a local authority or cooperative building association, and the tenant also needs to be a private individual. It's not competent to create a residential lease to a company, for example, as a company will not have a principal or only home. Instead, you will need a commercial lease of a residential property. Consideration must be paid, therefore rent must be charged, and if a rent is payable of less than £6 a week, a residential lease will not be created, and it may be that you have a licence to occupy in place. The landlord will be able to recover possession much more easily in this situation. So with that in mind, let's move on to the first type of residential lease currently in existence and the oldest type of residential lease, a regulated tenancy. If the lease was created prior to the 2nd January 1989, the landlord is not resident in the property or providing meals or other services, this is most likely to be a regulated tenancy. These types of leases are governed by the Rent Scotland Act 1984, and the tenant has a right to have a fair rent registered with a rent officer. The terms of the Rent Scotland Act 1984 will prevail over any lease terms contrary to the provisions of this legislation. Moving on to recovery of possession under a regulated tenancy regime. A tenant may serve a notice to quit on a landlord terminating a regulated tenancy upon giving 3 months' notice. However, tenants cannot be evicted unless the landlord serves the tenant with a 28-day notice to quit, and following the end of that notice period, obtains a court order for the tenant's removal. The landlord is also obliged to inform the local authority of the removal proceedings being raised against the tenant. The Sheriff Court, when hearing a recovery of possession action under a regulated tenancy, must be satisfied that there are actually grounds for repossession. As with the more modern legislation, there are mandatory grounds on which the Sheriff must grant possession, and there are further 10 discretionary grounds. It's worth highlighting here, however, that the removal of a tenant because of rent arrears will be a discretionary ground under the 1984 Act, and not a mandatory ground under the 1988 Act, as we'll see in due course. A further contrast with the more modern tenancies is where a property was let to a former employee and the property is now needed for a future employee under a regulated tenancy. Where the employee was an agricultural worker, then this ground for recovery of possession may be mandatory. Realistically speaking, nowadays, there may be a retired farm worker who retired in the last 10 years or so, who lives and has always lived in a cotter house on the farm since their employment began perhaps 40 years ago. I have done the maths and the dates work out. This farmer may still be in occupation of that same house under a regulated tenancy. So how about rent review? Rents can only be increased by following the specific procedure for registering a fair rent. This involves an application to a local rent officer or a private housing committee, now called a first-tier tribunal, who will fix the rent in the first instance. This is the maximum that can be charged. An application to fix the rent may be made by the landlord, the tenant, or both acting together. If the lease term as specified in the contract is still running, then the tenant can hold the landlord to that rent as specified in the lease. However, once that lease term comes to an end and the lease is then running on tacit relocation, the rent can then be refixed. This is probably likely to be the situation for all regulated tenancies in existence at the moment, in that they're running tacitly relocating. The fair rent is registered, however it can be altered by agreement between the landlord and the tenant without the requirement for registration. However, once it is registered, it will remain at this level for 3 years until another application is made to fix the rent. Therefore, we've got 3 yearly rent reviews. In the event that the new fair rent registered against the property is substantially more than the passing rent, the landlord is required to phase in the increase. Now, the phasing in is based on the greater of £104 per year, 25% of the passing rent, or half the difference between the passing rent and the reviewed rent. There is actually a fair rent formula provided in the 1984 Act at section 48. I don't intend to go into that today, but will leave you to look at that at your own leisure. Moving on to succession. Succession of a regulated tenancy is now more similar to assured tenancies under the Housing Scotland Act 1988. However, as ever, there are some exceptions. A spouse or a civil partner of a tenant who is in occupation under regulated tenancy can succeed under that same regulated tenancy, provided that they have lived in the property with that tenant. Any other family member who satisfy the conditions of succession will thereafter become assured tenants of the let property. This will be the same for a succeeding family member of a surviving spouse. For example, if a husband is the sole tenant under a regulated tenancy and his wife lives with him, she can succeed to the tenancy as a regulated tenant. If they have a daughter who also lives in the property, she can succeed as an assured tenant, but only if her mother, who is the inherited tenant, passes away prior to 2nd January 1989. The daughter or the inheriting family member must be related to the original tenant, in this case the husband. So for example, if the mother had remarried, had another child by her second marriage, this child could not inherit as an assured tenant, as she is not or he is not related to the original regulated tenant. If the regulated tenancy does transition into an assured tenancy, as noted, upon the death of that succeeding tenant, in our example, the daughter, then the recovery of possession can be obtained after the daughter passes away. The succession line stops. So that's regulated tenancies in a nutshell. Let's move on through the years, only 4 years later, to the Housing Scotland Act 1988, which introduced assured tenancies and a move away from the regulated tenancy regime. There are two types of assured tenancy introduced by the 1988 Act. The first, an assured; the second, which we'll probably most be familiar with, short assured tenancies. But let's start with assured tenancies first. Assured tenancies are created, as I've said, on or after 2nd January 1989, and they are assured tenancies provided that the property is let as a separate dwelling, at least one of the tenants is an individual and occupying the property as their principal home, and the tenancy does not fall in any of the accepted categories as provided for in the 1988 Act. There are some differences within assured tenancies themselves between contractual and statutory assured tenancies. Whilst the tenant remains in occupation by virtue of a duration specified in a lease document, the tenant's occupation will be governed by the terms of that lease document and contract. If and when a landlord serves a notice to quit and then the tenant remains in occupation, their lease will then be converted into a statutory assured tenancy, and the landlord can then only recover possession based on the statutory grounds provided in Schedule 5 of the 1988 Act. The statutory assured tenancy will continue on the same terms as the contractual lease was, but that the termination provisions and provisions in relation to review of rent will not apply. There is an opportunity for either a landlord or a tenant within 12 months of the conversion from a contractual to a statutory tenancy to alter the terms of the agreement. However, the alteration cannot include rent provisions. The rent can, although, be altered in light of the adjusted lease terms. Depending on whether the lease is a contractual assured tenancy or a statutory assured tenancy will depend for the process of recovery of possession. In order to recover possession where there is a contractual tenancy in place, the landlord must issue the tenant with a notice to quit on the basis provided in the lease, if indeed there is a basis provided. This should be a minimum of 4 weeks, and to be valid, it must contain information about the tenant's legal rights. The notice to quit, however, does not entitle the landlord to recover possession. It simply terminates the contractual position between the landlord and the tenant. If the tenant does not remove after the notice to quit has expired, the lease will convert into a statutory assured tenancy, and the landlord then requires a court order from the Sheriff Court on one of the statutory grounds for recovery of possession prescribed in the 1988 Act. The grounds are split into mandatory and discretionary and are all laid out in Schedule 5. The landlord is not obliged to show any reasonableness in obtaining vacant possession on a mandatory ground. It is enough to show that this ground exists. On the converse, for a successful award of recovery of possession from a sheriff on a discretionary ground, the landlord requires to show it is reasonable to grant the award. As regards irritating the contractual lease during its term, the contract must state the grounds on which the lease can be terminated or irritated. It is not enough to have a general irritancy clause. This will not be effective. There are a small number of grounds which apply to contractual tenancies. For example, landlord and mortgage default, 3 months rent arrears, alternative accommodation, or where the tenant was previously an employee, which will, as I say, apply to contractual but also apply to statutory. The mandatory ground where there are 3 months rent outstanding, the tenant must have 3 months outstanding at the date of the service of the notice to quit and also on the date on which the hearing appears in court. So if the tenant remedies their breach by having 3 months outstanding between the date of the notice to quit and the hearing, then the sheriff cannot hear a claim on a mandatory ground. Once the contractual term is brought to an end, the landlord requires to serve their notice on the proceedings for recovery of possession. So 2 notices required. One for the notice to quit to bring the lease to an end, and another for recovery of possession. A recovery of possession notice alone may not be sufficient to stop tacit relocation. The rent review process is probably where regulated tenancies and assured tenancies differ the most. In a move away from having rents registered, rents under assured tenancies are set at the open market. Where the contractual period of let is unexpired, the rent will remain as stated in the contract and the lease. The landlord and tenant are entitled to agree a new rent, and the landlord is also entitled to review the rent during the contractual period. The new rent, however, will not be payable until the contractual period is brought to an end and the lease becomes a statutory assured tenancy. Thereafter, once you're on a statutory assured tenancy basis, the landlord is entitled to review the rent according to the open market on an annual basis. There are specific notice periods for reviewing rent where the lease was for 6 months or more. The notice period is 6 months, and when the lease is for less than 6 months, it's a 1 month notice period. A tenant is also entitled to refer to the Private Housing Committee, now, as I've said, the first-tier tribunal, to fix an open market rent if required. And of course, the parties are free to agree any new rent at any time that they choose, so long as both parties are in agreement. So lastly, on assured tenancies or succession, differ slightly from regulated tenancies, but not too much. It's only a spouse or a cohabitant of the tenant that can inherit. A spouse or civil partner or cohabitee, and that inheriting tenant must have resided in the property as their only or principal home together with the deceased tenant. This is where the inheritance line will stop. No further family member can inherit. There is also a ground for repossession, so if a tenant has bequeathed his interest in the lease and that bequest is accepted, this is a ground of repossession against the tenant that the landlord has, if this is not to a spouse, civil partner or cohabitee. Moving swiftly on then to assured tenancies, I've already said this is probably the type that we're most familiar with, them having been the main type of lease in the private residential market of late. Now, an SAT, or a short assured tenancy, is a tenancy which would otherwise be just your plain assured tenancy, but where prior to the creation of the lease, an 85 notice has been served. Whilst many landlords may have intended to create a short assured tenancy, the lack of the service of the 85 or the fact that it was served after the date on which the lease began will not create a short assured tenancy. Therefore, in a worst case scenario, what we might have is a lease purporting to be an SAT, but is actually a contractual assured tenancy. That term has now expired and the tenancy has converted into a statutory assured tenancy. So beware when reviewing old leases as to what actually the tenant's position currently is. Short assured tenancies must have a minimum of 6 months duration. For the first 6 months, thereafter it can be reviewed or renewed for any period of time. If the lease continues past its natural end date of an SAT, it will remain an SAT. No new 85 notice is required to be served, and it will continue running on tacit relocation as a short assured tenancy. So how then can we recover possession of an SAT? They can be automatically, or recovery of possession can happen automatically at the end of the agreed term, provided that the landlord has given notice that they intend to terminate the lease. Now, there's no statutory notice to quit for a 1988 Act tenancy, a short assured tenancy governed by the 1988 Act. However, the landlord is obliged to give the tenants 2 months' notice to quit. Similarly, a recovery of possession notice should also be served in the statutory form of an 86, of which 6 months' notice is required. The tenant is also entitled to serve a notice to quit on a landlord. However, it's only 1 month in advance of the termination date that's required to be given by the tenant. The landlord can also rely on statutory grounds for repossession as per mandatory and discretionary grounds contained in Schedule 5 of the 1988 Act, the same as for assured tenancies. The difference with assured tenancy being that it's a mandatory ground where the lease has come to its natural end, if it's not running on tacit relocation and notices haven't been served correctly, and that the landlord has served the relevant notice and there's no other contract in place. Where a tenant does not remove following a notice to quit and recovery of possession notice, an application to the Sheriff Court will be required by the landlord to recover possession. Now, because of the short nature of a short assured tenancy, normally 6 months or a year, rent is not normally kind of reviewed in that period, and in any event, the landlord cannot review the rent during the contractual term of an SAT. Instead, the rent will be reviewed when the original lease terms come to an end. Thereafter, it can be reviewed once a year, with the landlord giving not less than 3 months' notice. Section 34 of the 1988 Act allows the tenant to apply to what was the Private Rented Housing Panel, now the First Tier Tribunal, for a determination of the rent if they think that the open market rent is too high. And the tenant can do this at any time during the contractual period of the short assured tenancy. Succession to SATs is just the same as with an assured tenant. So to a spouse, civil partner or cohabitee who's lived in the property with that tenant for the duration of the lease. Now, I've mentioned a couple of times the First Tier Tribunal. I just wanted to insert just an explanation about this here. The First Tier Tribunal is an amalgamation of the Private Rented Housing Panel and the Homeowner Housing Panel. And it came into force from December 2016 and is the forum for issues on rent, repairs and repossession, but only for PRTs. So if you're looking for a repossession of a assured, short assured or regulated tenancy, that will be through the Sheriff Court still. Only First Tier Tribunal you go to for private residential tenancies, which I'll come on to next. And hey presto, PRTs replaced assured and short assured tenancies from 1st December 2017. Any tenancies that do not fall into the accepted categories are private residential tenancies. Unlike with short assured tenancies, there is no minimum duration let for a PRT. They don't have an end date. There is no termination date. They're open-ended and will subsist for as long as the tenant wishes to remain in occupation, or in the event that the landlord can demonstrate one of the grounds for recovery of possession. Where the parties agree a lease will be terminated, then the landlord must issue a statutory notice to leave, stating the grounds for termination, but court proceedings do not need to be raised where you have agreement. The tenant can also terminate a PRT. The notice must be given in writing by the tenant, and there's no statutory form. The only requirement for them is that they have to give 28 days notice. So if you have a lease starting on the 1st of January, for example, a tenant can serve notice to quit on that 1st of January, and the lease will only be for 28 days. They will remove on the 28th of January in that same year. The tenant can change their mind. They can decide that they want to rescind their notice to quit, and if the landlord agrees, then the tenancy just continues on the same basis as was previously agreed. The tenant must give their notice freely and without coercion. Landlord's recovery of possession, they must serve a notice to leave. As I've said, there's no longer a right to terminate its end date, as there is no end date in PRTs. The landlord must state in their notice to leave the reason why they are terminating the tenancy, and it must be one of the grounds contained in the 2016 Act. To terminate the lease, the landlord has to be able to demonstrate that one of these grounds for recovery of possession are met. If the tenant refuses to leave, the landlord is required to apply to the first-tier tribunal rather than, as I've already said, a sheriff court for an order to evict the tenant. As noted, there are 18 grounds, and these are very similar to assured and short assured tenancy discretionary and mandatory grounds for recovery of possession. A number of these are identical, and some are slightly different. For example, in terms of rent arrears, there must be 3 months rent arrears when the notice to leave is served, but there only needs to be 1 month in arrears by the time the first-tier tribunal takes place. I've put on this slide just a couple of notice dates, times, and they're obviously just there for information. In terms of the recovery of possession grounds, I've also included the mandatory grounds for both assured tenancies and private residential tenancies. Secondly, the ones for only private residential, and thirdly, the ones that only apply to assured tenancies. I'll leave you to have a look through those at your leisure, and I've done exactly the same for discretionary. However, I don't know why I've tailored these slightly different. So first one is for assured tenancies only, secondly for PRTs, and then lastly for both assured tenancies and PRTs. A landlord may not increase the rent any more than once in a 12-month period under a PRT. The tenant must be given at least 3 months' notice before any rent increase can take place, and there's a statutory notice provided for in the legislation to be given to the tenant for this purpose. Within 21 days of receiving the rent increase notice, the tenant can refer the proposed increase to a rent officer if they think it's too high or unreasonable. They can't do this, however, if the property is located within a rent pressure zone. The landlord or tenant can appeal the rent officer's decision as to the open market rent to the first-tier tribunal, and then the decision of that tribunal as to fixing the rent is final. If the property is in a rent pressure zone, the effect of this is that it places a cap on the amount of rent which can be increased. However, currently in Scotland, there are no rent pressure zones in existence. So finally, what about succession of a PRT? This is something of a departure from the succession position under assured tenancies, and hopefully this kind of family tree here will help in assisting. So firstly, a spouse or civil partner or someone living with the tenant as though they were married can inherit the tenancy, provided that the landlord is aware that they were living in the let property, and this must be by writing to the landlord. The relationship between the tenant and their cohabitee or spouse or civil partner was still active at the time of death, and that the inheriting tenant had used the let property as their main or principal home for 12 months before the death of the tenant. They must also be over 16. I've popped that on the slide as well. It's crucial that written notification is given to the landlord to ensure that they are aware of the spouse or cohabitee's existence, otherwise the succession will not be possible. Looking through this family tree, if there is no spouse or civil partner which kind of fills the requirements there, then a family member over the age of 16 can inherit. They must also fill the regulations and requirements provided. And there's actually a defined list of family members in the 2016 Act. Going a step further, if there is no spouse, civil partner or cohabitee and no qualifying family member, a resident carer who has occupied the let property for 12 months prior to death of the tenant can also inherit the PRT. Now, the succession line only happens once, so as soon as one of these three kind of members has inherited the tenancy, that's where the succession line will end. So it opens up a little bit wider, but there are some requirements that need to be complied with. So that has been a whistle-stop tour through residential tenancies. What I do just want to kind of comment on is the fact I haven't mentioned anything about repairing standards. Who's responsible for complying with the repairing standard under the Housing Scotland Act 2006 and enforcing this compliance? This is particularly prevalent in agricultural tenancies where an agricultural tenant farmer is perhaps subletting one of the farmhouses under a private residential or other regime. They may also just be housing a farm worker. The government is actually holding a housing summit to discuss the implications of residential let properties included in agricultural tenancies. This is something, depending on what the outcome of this summit is, will likely have an impact on both landlords and tenants of agricultural holdings alike. And I suppose we're waiting with bated breath to see what the outcome of this summit will be in due course. Finally, it's only open for me just to let you know about our upcoming webinars in this season 2. The next one almost a month today on the practicalities of serving notices across the rural sector, but also more generally. We have access rights. I've split over 2 parts in November, and then my colleague Hamish Lean will be giving a subsidy appeals webinar on the 13th of December. As I've said, any questions in relation to this webinar, appreciate that it has been a whistle-stop tour. My email address and contact details are on the slide, so feel free just to send me an email. Thanks very much.